I've had a number of requests to do a video on jury nullification. What it means, whether it's allowed, spoiler, it's not allowed, but there's more to it than just that, and generally why there is this air of mystery around the whole term of jury nullification. So let's get right into it. But actually, before we get right into it, if I could ask you a small favour in exchange for the free legal guidance that I give you on this channel, helping you to understand law for over 2 years now and thousands of videos and countless thousands of hours that I've put into this channel, if you could hit that subscribe button, because I notice in my statistics that around 60% of you that watch this regularly are not subscribed to my channel. You might think that it doesn't mean anything and it doesn't matter, but I promise you it does. It matters to me, but it also matters to the YouTube algorithm and spreads my channel to a wider audience. So thank you for smashing that subscribe button just now and the like button while you're at it. Now let's get back into the video. So jury nullification has got this air of mystery around the term because many people say that we as barristers can't talk about it, which is strictly correct. So why am I talking about it? Well, this isn't a courtroom. This is my gym here. If it were a courtroom and during COVID we were doing trials in lockdown, and so this effectively became a courtroom from where I was practicing law, I would not be allowed to mention jury nullification. Not that we would have had a jury in here or remotely like this. I was doing civil trials, but nonetheless, if you are in a trial as a barrister, you cannot mention jury nullification because it would be contempt of court to do so, because it would tempt the jury into making a decision that goes against the law and the findings of evidence, which is against their oath that they take as a member of the jury. So, with that out of the way, let's explain what it means, and then it'll probably become clearer as to why we cannot talk about it and why it's contempt of court. So when you are called upon to do jury service and you are in the courtroom, and let's say the defendant hasn't given any reasonable objection to you sitting on that jury, you then take an oath before you can carry out your duty as a member of the jury. That oath is as follows: I swear by God of your faith, or I solemnly, sincerely and truly declare and affirm, which is the affirmation, that I will faithfully try the defendant and give a true verdict according to the evidence. So that's the key part there. According to the evidence, you are making a promise to the court and either to your faith or an affirmation to the court that you are going to try the defendant only according to the evidence. And what this essentially means is you cannot try the defendant, i.e. come to a guilty or not guilty verdict, based on anything else that you've heard or read about. You cannot research the case. You cannot talk to other people about the case. The judge will be very clear and very strict with you that you must not discuss this outside of your jury number and outside of court. In fact, there have been cases where jury members have been brought to prosecution for contempt of court and been sentenced to 6 months in prison because they've revealed what was being discussed inside the jury room after when they were outside of court. Now, the same is true for what is referred to as jury nullification. So let's talk about what this means and why it would be contempt of court. Jury nullification, as the academic term that we're discussing it as here, is where a jury member decides that on their own decision and their own morals or whatever other reason it might be, that they are going to decide whether the defendant is guilty or not guilty, but not based on the evidence, based on some other factor, such as research or having heard about it, or just a moral objection to the crime at hand, regardless of whether it's guilty or not guilty. If any of those other factors come into play for the decision, as against the evidence presented at court, then it's going against the oath that they've sworn to the court and to their faith, or as an affirmation, because they would not be trying the defendant faithfully and properly according to the evidence. Now, many of you might then say, well, how would anybody know if the jury member is doing exactly this? Well, very often they will mention this to other jurors, and those jurors in turn can report it and must report it to the usher, in turn will report it to the judge, and then very often the judge is going to order a retrial if there's been outside research into the case, or if the judge believes that the jury have been contaminated in their views and that a retrial is the only just and fair way to proceed. And of course that is at great expense of taxpayer money and time and all the rest of it, not to mention the justice or the injustice to the defendant and the complainants, because if the defendant turns out to be innocent, then they've been on trial for much longer than necessary, necessary, or if they turn out to be guilty, then the complainant and then would-be victim has been waiting for justice for far too long, and as the saying goes, justice delayed is justice denied. So all of this is absolutely a big fat no in the eyes of the court for a juror to decide the case on anything but the evidence before them. And if they do discuss that with other jury members, then they can be held in contempt of court and committed to prison, if that's being the case. Now, you might remember that just over a year ago, the Colston Four were acquitted of criminal damage, much to the dismay of many MPs, and posing what they saw as a threat to the rule of law, because nobody really knows what the reason was, and they won't know what the reason was, that the jury decided to acquit them of criminal damage for pulling down that statue. Now, at the outset of the trial, as I said, jurors take an oath to give a true verdict according to the evidence, but afterwards they are not required and indeed not even permitted to provide a reason that they came to their verdict. So this is the reason that jury trials and the potential abolition of jury trials has all come about just recently, and has been the subject of much philosophical debate, in fact, for many years. But overall, the position remains that the jury should be deciding the case on the evidence and the evidence alone. And if it is found that they've acted outside of that oath and they've been researching the case, or they've been discussing it outside of their jury number and outside of the jury room, and let's say deciding the case on morals rather than anything else, if this does come to the attention of the judge, they could well find themselves in contempt of court. So I hope that's a useful overview and why barristers never mention jury nullification in court, because it would potentially be contempt of court to do so, and ultimately it's what we refer to as a perverse verdict, meaning one that didn't come about through consideration of the evidence alone, which is what it absolutely should be. So please smash that like button and subscribe, and as always, thank you for watching.